we actually need to have a strong role for antitrust enforcement in this situation to make sure that competition actually does happen, that we actually do have a free market sorting out the true winners and losers, not large market incumbents leveraging their monopoly power to dictate and influence the direction and flow of innovation. Right. You want to make sure that going forward, they can't just keep doing the same thing in a slightly different way. We've seen comments from both FTC and DOJ that they're very focused on AI and protecting competition in AI to make sure we don't have a repeat of what Google's been able to do in the search space.
Howdy, everyone, and welcome back to Moment of Truth, the podcast of American Moment. My name is Saurabh Sharma. I'm the president of American Moment, and this week it is just me. I believe Nick is 2 days past his new baby's due date, and there's no baby yet, so he's definitely not driving out to DC. Wishing him congratulations if the baby's come by now. Otherwise, please keep him in your prayers. This week we had on a fantastic returning guest, but before I get to that, be sure as always to go to americanmoment.org. I think we've wrapped up our summer programming at this point, but you can still sign up for AM Fridays for the fall, as well as reach out to us at americanmoment.org/join if you'd like to get involved. As you can imagine by the news cycle, there is a lot of interest in potentially getting involved in Washington these days, and we're happy to help anyone who's interested in doing so get involved. You can also find the backlog of our podcasts and everything else we have going on at americanmoment.org. This week I had on an old friend at this point. I get in trouble a lot in DC because I say like, oh, someone I've known for 7 months, my old friend so-and-so. David Azarad loves to make fun of me for this, but it feels like I've known Mark for a long time. He's been on the show before. He is a partner at Kressin Meador Powers, which is a fantastic antitrust law firm here in Washington, DC. He has led and participated in complex investigations as both an antitrust enforcer at the Federal Trade Commission, in the Bureau of Competition's Healthcare Division, and in Transportation, Energy, and Agriculture section of the Department of Justice Antitrust Division. He was deeply involved in FTC's efforts to combat pay-for-delay agreements and product hopping in the pharmaceutical industry. At DOJ, he played a key role in several high-profile investigations, including the division's successful challenge of Visa/Plaid. He served for a total of 4 years as the senior Republican antitrust attorney for the Senate Judiciary Committee, both as a detailee from the FTC and DOJ, and as Deputy Chief Counsel for Antitrust and Competition Policy for Senator Mike Lee. He has previously worked at other major DC law firms before he came to Kressin Meador. He speaks for the Federalist Society, writes for Heritage, does all sorts of awesome stuff around the movement. He is one very bright cookie, and anytime that there's antitrust in the news, he's definitely the person we want to talk to. This week, there are two big stories on that. One, Google has lost its case before the district court in Washington, D.C. about the monopoly that they have over search and the ad market. And Twitter and Rumble have brought a case against the World Federation of Advertisers for their coordinated advertiser boycott. So we talked to him about both of those. He has to be a little bit tight-lipped about the second case because he's actually involved in it, representing Rumble. But he was able to give us a little bit of a high-level overview as well as some prognostication of how the landscape of antitrust policy is changing here. Was a really fun episode. If you have a multi-trillion-dollar antitrust case you'd like to bring, I'd highly recommend going to Kressin Meador Powers. Just some friendly recommendation, but I'll let him do the rest of the talking here. We'll go now to Mark Meador. Mark, thank you for coming back on the podcast.
Glad to be here.
Returning guests, we're always excited to have them. It means that you didn't completely screw up last time, so congratulations.
Glad to clear that bar. That's always good.
It also helps that there's a lot of very interesting things in the news, and you're one of the few people that can talk about this topic intelligently. So congratulations on finding a market niche. Antitrust. There's been a lot of interesting things going on in just the last few days when it comes to the antitrust issue. The first of which is a decision that came down in a big lawsuit against Google. I'm going to ask you to treat everyone in our audience like they're giggling morons and 5 years old. Explain the lawsuit, explain the decision, and why it matters.
Sure. The easiest way to explain it is probably to do a quick introduction on what you have to show to prove a violation of the Sherman Act. So DOJ brought a suit against Google under what's called Section 2 of the Sherman Act. This deals with monopolization.
When was this suit brought?
This was brought by the Trump administration in late 2020.
Okay.
So it's taken us almost 4 years to get to a verdict. It may stretch out even further. We'll talk about that in a minute. The claims were pretty straightforward. In a lot of ways, it's very similar to the suit brought against Microsoft in the 90s. Again, two parts to an antitrust claim under Section 2 monopolization suit. The first is to show that a company has monopoly power. It doesn't mean 100% of the market. We hear that a lot of times. People say, oh, how can Google be a monopoly? Look at all these other search engines out there.
Yeah,
it's like,
you can use
often,
Yandex.
Right, yeah. And how often do you use those? Like, I kind of chuckle. It's hard not to roll my eyes, but we hear that a lot. Like, monopoly does not mean literally 100%. Right. It means that you can control, traditionally means you can control price and output. You can control whether or not other firms are able to enter the market, right? It's about control. So you have to show monopoly power, and then you need to show exclusionary conduct. So it's not illegal to have a monopoly, right? You make the best widget, everybody wants to buy it, and you have 90, 100% market share. Great. Like that's how the marketplace works. Now you create the incentive for somebody else to innovate and do something better and steal that monopoly share. So it's not illegal to have monopoly. It is illegal when you have monopoly power to engage in certain kinds of conduct that go beyond competition on the merits, right? So if you have the best product and you offer a lower price because you have big factories and you can do things at scale and you're more efficient, that's good. We want to see that. That's competing harder. That's passing benefits of your efficiency on to consumers. What you're not allowed to do is engage in conduct that keeps your competitors from being able to even get into the marketplace, that prevents them from being able to fight on the merits, right, of whether or not they have a better product. So that could be, as in this case, contracts with distribution venues that lock up the marketplace. And essentially what DOJ alleged is that Google had obtained monopoly power in the market for general search services and then had maintained that monopoly, not by offering the best search service and, incentivizing all of the users to come use Google instead of Bing or Yandex or whomever, but that they had locked it up and protected their monopoly by entering into a series of exclusive arrangements with browsers, smartphone manufacturers, and others that made Google the default, and no one else could be the default on all these different venues. And the court essentially agreed with DOJ's arguments that Google, one, had monopoly power, and two, that these exclusive contracts were harming competition. This wasn't competition on the merits. It's not about competing for the contract. That was one of the arguments Google made, and the judge rejected that and said, no, it's locking out the most efficient means of distribution for its competitors, and it's a substantial part of the market. So that's basically the decision. It's pretty simple when you boil it down to the basic holding. It was a very complicated trial. There's a lot going on. There were some other claims.
Tell me about, like you said, the court. Where is this court?
Yeah, so this is the federal district for the District of Columbia, Judge Amit Mehta.
Why is this court being litigated why is this decision being litigated in DC? It's
typical for the antitrust enforcers to bring suits in DC. I mean, they can bring them wherever a business is found. But with the agencies here, I think it's a matter of convenience. And so it was I think an 8-week trial or maybe 10-week trial. I'm trying to remember. It was long trial, extensive amount of witnesses. There were a number of states involved as well. There were some other issues that they argued over. There was the general search services market. So search engines, the one we all know. But they also talked about different forms of advertising within search. That's how you monetize a search engine. So they went through all of that. And ultimately, the judge said Google has monopoly power in search engines and text ads on search engines, and then found that it had illegally maintained that monopoly through those exclusive agreements.
So you keep saying exclusive contracts. Explain to me how one of these exclusive contracts actually works, say with Apple or any other company. What are the sums of money at play, and why does it actually matter? About
$26 billion in a year is the answer. That's the sum of money we're talking about, $20 billion to Apple alone. Mozilla, for example, their browsers, about 80% of their revenue in a year comes from these payments from Google. And the arrangement is pretty straightforward. It's Google shares their monopoly rents, and the other parties in turn agree not to make any other search engine the default in their browser, smartphone, wherever.
But Mark, I can hear the libertarian saying, I can type in Bing.com into my phone. So what does it matter?
Oh, yes. Competition is just a click away.
Yeah.
Until it isn't, right? Yeah. I mean, there's pretty extensive evidence that that's not how consumer behavior works. There's a really good example actually with mapping software. So, and this came up at trial. You might recall that Apple at one point moved away from Google Maps and decided to use Apple Maps instead. That was devastating for Google. To date, I believe they've only recovered 40% of the traffic on iPhones that they previously had before, when Google Maps was the default. And, commentators have pointed out that, hey, Apple was sending a really strong message to Google of we matter, and the default status matters. And this influences what people can do. Anybody could go use Google Maps. It was a click away. It's right there on their phone, probably. I mean, how many people only have Apple Maps installed? The competition was a click away. And yet, for some reason, people weren't going to Google Maps. I mean, I think many of them probably prefer Google Maps if they had their choice, but it was there. It was on the phone.
And Maps is an incidental business unit at Google. I mean, is it understood that this was sort of an intentional Machiavellian play from Apple, where they said, like, hey, we could come for the golden goose on search, and then you guys are screwed?
I suspect it was a very clever marketing position to show them what they could do on search. And the documents at trial backed that up, that there were intimations that Apple was considering getting into search and building its own search engine. And instead, they took the easy route and they cashed a giant check from Google. But that gave them the leverage to get it from Google. The competition is a click away argument really can't get around, and this was the weakness at trial. That's why they lost. Can't get around this idea that, if you're going to argue, well, people will choose Google anyway because it's what they prefer and it's better. And so what's the harm? Well, if they're going to choose Google anyway, why is Google paying billions of dollars to be the default? Right. Clearly, Google recognizes the value in default status, and it values it to the tune of $26 billion a year. So that argument it's not consistent with the facts. It's not consistent with how Apple and Mozilla view the world. It's not consistent with how Google views the world. It's a convenient post hoc justification for what's plainly anti-competitive behavior.
So walk me through what this trial was actually like. Is this like a courtroom drama, like for any criminal trial, or who are these jurors? How exactly was this adjudicated? It seems like it was probably intentionally by the tech companies highly abstracted and technical, but how did it actually play out?
It was not Perry Mason. I don't know how many of your listeners even know what that is, but I don't think there was a lot of drama per se. There were some exciting, documents and witnesses, no jury. So this was a bench trial. So the judge was the fact finder. And again, over a couple months of going through documents and testimony in court, you have to remember, like, this is almost 4 years, at the time of the trial, 3.5 years after the complaint was filed. There'd been years of investigation prior to that. So a lot of this has happened even before you get into the courtroom, as far as DOJ did a full investigation. They were taking depositions before they file a complaint, reading documents, collecting evidence. And then that process plays out. So a lot of it at trial, right, is bringing up things that everybody already knows about, trying to portray it in the light that supports your argument, whether you're the plaintiff or the defendant, and arguing to the judge about how he should interpret the evidence.
So what exactly did the decision say in the end? And what's the steps forward from here? I assume Google's not going to take this sitting down. It's going to get appealed. What exactly is the process for something close to a final resolution here?
Sure. So as I mentioned before, the final holding is pretty straightforward. It's a 280 some page opinion. So it's not light reading, but at the core, it's yes, Google has monopoly power in a couple markets, and yes, these exclusive agreements are anti-competitive. Therefore, it's violated Section 2. So the next stage is going to be sorting out remedies. Now, before we get to what has to be done to fix Google's violations of the Sherman Act, I'd expect they're going to appeal. So I think they'll appeal the finding of liability, and they'll ask the court to stay any proceedings on what the appropriate remedy should be. This is something where I think, it will very likely go to the Supreme Court for Google. It's existential in a lot of ways. This is the core of their business. They certainly have the incentive to fight it all the way up to the Supreme Court.
When was the last time the Supreme Court took a big antitrust case?
Amex was probably the biggest one in recent memory. There's been some others, but it's infrequent. We don't get a lot of antitrust suits.
What was that Amex case, and when was it adjudicated?
So that was 2018. It focused on what are called steering rules with various credit cards. So that has to do with a merchant trying to steer a user to a credit card that has a lower transaction cost as compared to others that have higher transaction costs. And there, ultimately, the Supreme Court sided with American Express. It had to do with we won't get into it now. It's very complex. It has to do with two-sided markets and how you balance harms and efficiencies on both sides of a market.
What does the way they ruled there tell you about the kind of temperament that the Supreme Court justices have towards antitrust policy in general, I guess extrapolate out with this Supreme Court, are they likely to find Judge Meda's argument credible?
That's a good question. Now, we've had a lot of change in the makeup of the court since 2018, so some of that's hard to say. I think that decision is viewed as being very pro-business and deferential to certain economic claims and claims about efficiencies and how they play a role in the market. I think some of that is probably still true for many of the justices. But I also think this decision is more straightforward. Amex is a very complex case. People were asking beforehand, like, how do you think the court's going to rule? And my response was, I don't know, but they'll probably get it wrong either way. It's hard to, to really slice and dice that correctly. This one is pretty simple. I think Google likes to make it seem more complicated than it really is. But as I said, this closely mirrors the Microsoft decision. It's a pretty straightforward case to say you have monopoly power. You're entering into exclusive agreements to keep your competitors from being able to get into the marketplace. That's bad. Right. It's not a hard story to tell. And I think, if this went to the Supreme Court and they sided with Google, they would be gutting Section 2 of the Sherman Act. I'm not sure what it would mean or stand for if they overturn this case.
So a lot of what Lena Khan, Jonathan Kanter, and others have brought to the antitrust conversation is, I don't think I'm being uncharitable when I say maybe novel or entrepreneurial interpretations of antitrust law. I've been seeing this kind of meme floating around the last few days. It's the kind of guy sweating with the two red buttons, and it's like, what are the libertarians complaining about? We don't need new antitrust laws. The existing ones are sufficient. Enforcing this antitrust law is bad. Like what exactly? Because in this case,
to Joel Thayer.
Was that a Joel tweet? Yeah. So how creative is Judge Meda's decision here, or is it pretty black and white conventional understanding of antitrust law?
This is pretty vanilla antitrust, in my opinion. This is not stretching the bounds. I do think it is really funny, right? When I worked on the Hill, we were in the middle of debating whether we should have all these new antitrust laws. And, it was all the Chamber of Commerce and libertarian groups and the big tech shell groups. I'll be like, oh, we don't need new laws.
The Sherman Act,
Sherman Act is great. Like, we have existing antitrust laws. You should just enforce them. And then it turns out they don't want to either fund the enforcement of those laws or actually have them be enforced when they get into court. Ultimately, those people just don't think we should have antitrust. Yeah. Some people say that. I wish they would just be upfront about it. That's fine. Like, that's wrong, but it's a position you can take and be consistent. Yeah. This one is not that, right? I'm personal friends with Jonathan Kanter. I think they've done a lot of good work at the agencies. There's not everything I would agree with, for sure. But it has been a little amusing to me over the last few years to compare the rhetoric and the speeches and the interviews and the press that are given about antitrust enforcement with what actually gets filed in complaints when they go to court, because they're kind of in two different worlds. Now, this complaint was filed under the Trump administration, so they didn't write the complaint, but they've prosecuted it, and I think they've done a good job. It's nothing crazy, right? This is a conventional antitrust theory. It's well within the bounds of existing case law. There's no novel theories involved. They're not stretching to apply this in any weird way. It's pretty straightforward.
Do you think the case is better because it was filed in the Trump administration, probably with tighter guardrails than may have been pursued during a Biden administration?
It's hard to say. I look at the other cases that have been filed under this administration, like the ad tech one, and I have the same view of the ad tech case. It's not a novel theory, right? They're not stretching the bounds of the Sherman Act or even of existing case law to get to what they say should be the outcome. So I don't know that it would have been that different. Tactically, as a prosecutor, you want to lead with your strongest case, and the exclusive agreements that Google had in place as a monopolist was the strongest case. You don't need to get into all this other stuff when you can win on a solid core theory.
Talk me through what the range of remedies is. Like, okay, so suppose it gets appealed up, the Supreme Court endorses the basic contours of the argument Judge Mehta laid out. What does that world look like the next day? What kind of things could happen to Google? How could they be required to behave?
So the way I expect it would play out is that they're going to get a stay on the remedies part, right? So there's going to be another mini trial essentially over what should be the remedy here. Mm-hmm. I wouldn't be surprised if they get a stay for that while they appeal on liability. So if it's upheld on the liability part, it goes back to the district court. We'll finally have that trial on.
Does this need to go through the DC circuit first?
Right. It'll go through the DC circuit and then Supreme Court potentially, and then it'll come back to Judge Mehta to determine what the remedy should be. when we get to there's two large buckets when you're talking antitrust remedies. One is structural and one would be behavioral or injunctive relief. So structural is sort of, should we break up the company? Is there a line of business that needs to be separated? It's a little hard to see, Google search. It's like all of that being broken off from the rest of Google.
But also that wouldn't solve the problem, because the problem is the search
right
division having these contracts with other companies, right?
So you could see, maybe Android is spun off, maybe Chrome is spun off, right, to separate that link between the two. There's the number of permutations you could look at. I think, the most likely outcome will probably be some form of injunctive behavioral remedy. The low-hanging fruit here is the court has said these agreements are anti-competitive. So I could see, I think table stakes, right, is an injunction that says you can't do these agreements anymore. So Apple's not getting $20 billion a year to do something they would do anyway, theoretically. At least that's what Google claims. So you can have injunctive relief that stops the exclusive arrangement so that others have an ability to come in, right? You could have a place where Google's a monopolist. When you're a monopolist, there are things you can't do that other businesses can. Like that's the way our law works. Monopolists are held to a higher standard than other businesses because they have the ability and the power to keep others out of the marketplace. And we want to have open competition. So we could have a world where Google is not allowed to enter into exclusive distribution agreements, but smaller competitors are. And that's going to give them a foothold to get into the marketplace to offer that alternative to users. That doesn't force anyone to use them, right? Users will still be able, competition will still be a click away. So, if they want, they can still go use Google if that's what they prefer. No one's going to take Google away from anyone. No one's going to break Google. So we can have that kind of arrangement, right, where we create the opportunity for new competition to enter the marketplace. I think we're going to see a lot of VCs suddenly interested in investing in search competitors. Right now, that's dumb. Like, you're not going to throw your money into a company that has no pathway to the market, right? You're going to get crushed by Google. There's no opening. Now, if you're in a world where you're just kind of competing against Bing and DuckDuckGo, and the Apple and Mozilla and others are going to be looking, well, who wants to pay me to be the default? They may not care if users switch it later, but they'll take money from someone to be the default in their browser or on other Samsung devices, maybe. Yeah. And that could be just what those companies need to get in and get enough users on board that then they get scale in the data to improve the product further and actually compete against Google and create those viable alternatives that consumers have been deprived of so far. So that's kind of like, that's the first part. That's dealing with the harm that's already happened.
I guess just on that, it seems like then in the short term, the companies that would be most injured by a punitive decision here would not actually be Google. It would be Apple. It's getting $26 billion a year from Google.
Right. Well, Apple, it would not be inappropriate to question why Apple wasn't named in the suit. I think they wanted to get this suit out and filed, and they did it the cleanest and simplest way they could. But there are strong arguments to make that Apple should have been named as a defendant, right? Because they were also agreeing not to compete, right? They're cashing that check from Google instead of offering their own search engine. Mm-hmm. So Google's going to have to up their game because they're going to have to win users on the merits now. Mm-hmm. Who hasn't complained about how much Google search sucks today? Yeah. I mean, you and I've been using Google since it existed, when it was in middle school when it came out, and watched it get really good and become the best search engine and then just kind of taper off. And that coincides with when they were coming up to monopoly power, right? Once they lost that pressure from competition, there's no incentive to innovate, to improve their product. And now it's full of ads. The results aren't as responsive. It's full of all their biases that stop me from getting the results I actually want. It's the worst search engine except for all the others, right? So now they're going to face those competitive pressures to improve their product. Apple is going to they're going to actually be in the marketplace now. They're not going to be able to free ride and just coast on sharing in Google's monopoly rents. They're going to have to, decide, hey, well, maybe we should make our own search engine because now their incentives are changed. So that's good, right? They're going to need to compete.
Yeah. And the thing is that if Google's monopoly power the only reason that they're able to pay $26 billion a year is because of their monopoly rents. It seems like the result is no one's going to be able to pay that kind of fee. And so you're going to almost necessarily see a winnowing down to this one result, which is the proliferation of more search engines.
I think that's the idea. And, and Apple could look at this and say, well, we could cash a much smaller check from a rival search engine, or we could make our own search engine and keep all of the ad revenue that we would get for our users. I think that's the most likely outcome.
An antitrust suit against them 10 years later for making their own search engine the default on their devices.
No, I think that's going to be that'll be a hard sell. But and it'd be one thing if they have a search engine that's the default on their own. That's not going to equate necessarily to like a monopoly across the entire marketplace. But hey, I think we would all love to see.
It's like the side-loading app stores thing, though, right?
It depends, right? If they're doing something that locks people out of providing an alternative, maybe, right? There could be harm there. And hopefully they learn their lesson from the app stores, and there's a case on that as well. I am actually old enough to remember when there was a genuine search engine battle, and you had, Microsoft, Yahoo, Ask Jeeves, like Google, like, right. Like all these stuff people can't even name anymore. And you had competition until we, sifted out to the one that was the best. And hey, it'd be exciting to live a bit of the early .com days, not the bubble part, but at least the options, the competition where we have something new injected into the space. And we can actually choose between things, and they're going to last for more than a day because they're not getting crushed by the market incumbent. And we can actually pick which ones we like.
Okay, so banning these kind of contracts, and then what was the other kinds of remedies? Right.
So that when you're looking at antitrust remedy, you want to make sure you're stopping the bad conduct, making sure the monopolist isn't keeping the fruits of their unjust conduct. But then you want to future-proof it, right? You want to make sure that going forward, they can't just keep doing the same thing in a slightly different way. That's where this is going to get a little more complicated, and it's going to be a hard nut to crack, but it's something I think the court will take seriously. And I know it's on the department's mind. And that's to figure out what part of the remedy, or what can we add to the remedy to ensure that Google doesn't leverage its existing monopoly in search to harm or take over additional markets, right? AI is top of mind. I think that's, we've seen comments from both FTC and DOJ that they're very focused on AI and protecting competition in AI to make sure we don't have a repeat of what Google's been able to do in the search space. I know there's concerns over how Google can leverage its power over its monopoly power in search to gain an unfair advantage on AI, whether it's getting access to content, scraping data, what have you. So I think there's going to be a lot of focus on how can we make sure they don't just use the same playbook in a different market or in a slightly different way.
It's interesting you bring up the AI thing, because that was going to be my sort of next line of inquiry, which is it feels like in real time, we are creating a similar world on the AI front. Most recent news was at WWDC this year, Apple announced this, what seems like an exclusive agreement with OpenAI, where it will furnish a large portion of their AI inquiries. How is that market situation developing? I mean, it's the same player. I mean, it's Microsoft coming back. It's like, when did the consent decree expire? And it feels like they're back to their old tricks. How do you handicap the state of the AI market right now when it comes to these same sort of principles that are so concerning about how Google has operated?
Yeah, I think we're at an inflection point. Something that you hear a lot is this idea that in quickly evolving markets, and 10 years ago, so this was a common talking point when it came to antitrust and tech, when people first started thinking through this question of how should the antitrust laws, how should a law from the 19th century apply to 21st century technology? And this sort of like de facto view gained a lot of ground that, well, these are quickly evolving markets. There's a lot of innovation. They move fast. So government should take a hands-off approach and not get in the way, right? We don't want to mess it up. We don't want to hold anything back or screw up the free market as it develops and figures out what's the best option here. We tried that. It hasn't worked out so great. And I think people now recognize that we actually need to have a strong role for antitrust enforcement in this situation to make sure that competition actually does happen, that we actually do have a free market sorting out the true winners and losers, not large market incumbents leveraging their monopoly power to dictate and influence the direction and flow of innovation, right? innovation doesn't happen in a vacuum. AI is not happening in a vacuum, right? So, when you look at the cloud computing space, we've got monopolies there too, right? We have it in chips and NVIDIA with a 90% market share. You need cloud computing capabilities. We have 3 companies, and guess who they are? Amazon, Microsoft, and Google, right? You need data. Who are the companies that have the most data? Amazon, Microsoft, Google,
and Meta.
Apple, maybe Apple-ish, Meta, right? Yeah, so maybe 5, best case. I kind of chuckle when people say, look how much competition there is in AI. There's all these AI startups. I'm like, okay, how many funders involved?
Yeah.
Right. Like how many companies are supporting them? And when you back it all down, well, how many cloud platforms are they on? How many chips are they using? I think there's going to be a lot of consolidation in the AI space. And I think that we are already seeing the large incumbents in adjacent markets positioning themselves to make sure they don't get left out. There's nothing wrong with them trying to be involved in the next market. We want companies to compete and innovate and work to future-proof themselves, and we want their businesses to succeed. We don't want them to leverage their incumbency to stop the startup from the garage who maybe is going to do this better, right? These large companies, their interest is not to have the best possible AI technology that they can develop. Their incentive is to have a technology win in the marketplace that they control. We want to make sure the best one wins. They just want to make sure they win. And so antitrust has a very important role to play to make sure the best option wins, not just the biggest one that's already there with an established market position that maybe has a bottleneck control over cloud computing or chips or some other facet that's an essential input. So I think that's the lesson that people have learned the hard way over the last decade or two. We can't be totally hands-off in this space. Competition is not going to take care of itself. I hear a lot of times, there's this Schumpeterian idea of creative destruction, and it's a very long view. Like, well, yeah, eventually, no monopoly is going to last forever. And it's like, okay, great. So I guess, we'll just monopolize cars until we have personal airplanes or something. Like there's suffering that happens along the way. But it all goes back to my point that innovation doesn't happen in a vacuum. And if you actually believe in innovation and you want products and services to improve and outcomes for consumers to improve, you need to protect innovation. You need to make sure that it's actually flourishing and that the entrenched incumbents that have market power or monopoly power are not stifling innovation and limiting it to only growing in ways that benefit them, right? So we do need to, it's not about dictating markets, it's not about controlling markets or having a top-down approach, but we need the police, we need the referees there in the game to make sure we have free and fair competition so that the free market works the way it's supposed to.
So the thing that's so interesting about the AI stuff is that it seems like large incumbents, basically giant pools of capital, seem to be close to the only game in town. It's like either you can go get like $10 billion of venture capital funding, or you can just be sort of a barnacle attached to a major company like Alphabet, Meta, Microsoft, Apple, whatever it might be. Is there any way around that? I mean, just the amount of startup capital required to start these AI companies, does it mean that this is going to be kind of a large firm game for the foreseeable future?
It's certainly possible, and that's something that I think a prudent antitrust enforcement policy has to take into account is not eliminating all of the possibilities of investment in order for these startups. Usually, when we talk about startups, we think about 3 guys in a garage, but when it comes
3 guys in their 4,000 A100s.
But the reality is that a startup like an AI, like you said, could need an immense amount of capital, and you want to make sure that's still possible. I think we'll have a similar dynamic that we've seen in other markets where when a new technology comes onto the scene, it's difficult. Right, you're doing something new, it's difficult. And so it can be very capital intensive to do the R&D and the development to get to this new place in technology. As it evolves and progresses, it could be something where, a lot of the early work has been done and startups can come in and kind of layer on top of that. I think AI has already gotten easier in that, like, you don't need the huge data sets that you used to need. Like, you can piggyback off a lot of open source material and then refine and fine tune it. So I think that's something that'll change over time, but we obviously have to keep an eye out for how it's developing along the way.
We're in a really interesting place when it comes to the startup technology ecosystem's attitude to antitrust. Like it feels like every other week Lena Khan's doing an event at Y Combinator. Now there's interesting reasons behind the scenes that you and I know about why that might be happening. But do you think that there is some sort of equilibrium to be reached there where the startup industry, which is by no means, little kids on the block, I mean, it's some of the biggest financial firms in the world are heavily invested in it, can have a relatively harmonious relationship with strong antitrust enforcement? It seems like there have been opportunities for that at scale during the Biden administration, opportunities that have been left on the ground where, they'll choose to go after more innocent characters than I would prefer for them to dedicate resources towards. Walk me through how you think of the dynamics here.
Yeah, I mean, I think first we got to recognize there's a wide array of VCs. There are smart, aggressive VCs, and there are lazy VCs. JD Vance has made some good comments on this earlier in his career when he was a VC, and realizing that all of them they come out of investment and they're like, what's the exit? How do I make money? And in the technology space in Silicon Valley, a lot of times the exit is acquisition, right? And so I think if you're kind of a lazy VC, you're just like, well, how can I get acquired, right? So I don't like M&A. I don't like M&A interference by FTC and DOJ. I hate the HSR Act. I don't want the government stopping my mergers and acquisitions. Just let me sell and get my money back. JD recognized that, hey, if you really want to make money, like you need to be investing in the technology that can disrupt, that can actually create a new market, that can, paradigm shift the way technology works. And you can't do that if there's a handful of major companies that control the entire marketplace, right? And so antitrust enforcement can actually open up and create opportunities for smart and aggressive VCs to invest in companies that wouldn't have had a chance if a Google or an Apple or an Amazon is completely dominating the sphere, right? When getting acquired by one of the big tech firms is your only exit pathway, that's going to limit what kind of companies you're going to invest in. You're not going to invest in something that directly challenges their business model because they're just going to crush it. They know that you have no pathway to market, that you're not going to be able to compete with them. So maybe they'll buy you for pennies on the dollar. Taking it back to what I said about, the search case, by getting rid of these exclusive distribution agreements and actually creating even just the possibility that we could have competing search engines, I'd expect to see VC money flowing into search startups saying like, hey, now there's a way out there. Now you could actually get to the marketplace. You have a chance. The cream can rise to the top. And there's a possibility to make a buttload of money by doing smart investing in guys that want to challenge the status quo and actually change things. So I think, within that whole framework, I think the smart VCs should be looking at antitrust and saying, this is an ally to investors because it's maintaining competition, right? It's opening up markets. It's preventing markets from being ossified and stagnant and being dominated by one large player. And when you break that up, you create a lot more opportunities for innovation, a lot more opportunities for investment. People can make a lot more money when markets are vibrant and competitive.
A couple of days ago, I saw a video from Linda Yaccarino, who is the CEO of Twitter, announcing a lawsuit that Twitter, or X, I suppose, is going to be filing about the censorship and sort of cartel-like behavior by ad networks or advertisers. What is this case? Walk us through it. You're a little bit close to the situation, so I understand that you have some limitations.
Yeah, very, very close situation. So my firm represents Rumble, who brought a very similar suit on the same day in the same court against the World Federation of Advertisers.
What's that?
So the World Federation of Advertisers is sort of a trade association whose members include all the major ad agencies, ad buying firms that collaborate on various standards and things for the industry. So I can't comment on our case or X's in any of the details, but I'm happy to talk about some of the substance at a high level. My first reaction even before I was involved in this, when the news broke about the House Judiciary Report, a lot of this came out of a report the House Judiciary Committee issued as sort of an interim report based on an investigation they've been doing. I think it was prompted when Elon Musk bought Twitter. And very quickly, you started hearing rumblings about an advertiser boycott of the platform. And I believe they started to look into it. They collected documents. They released a report. And, we've talked about, I was on the Hill for years, and was up there when a lot of these debates about censorship and antitrust were going on. And over again, you hear people saying, hey, I know conservatives are upset about big tech censorship, but even if censorship is bad, it's not an antitrust problem, which is true for a bit. Companies that have market power and a large presence, they exacerbate the harms of censorship. But, one company choosing not to platform the speech of one other company or a person is not in and of itself an antitrust violation. So censorship isn't an antitrust problem until it is, right? And this is what we seem to be seeing now because it's not one company, right? At a high level, the concern is that you have a number of competing competitors getting together and agreeing to collectively not do business with a certain set of other companies. And it's not purely speech. It's not a social cause, right? There are economic considerations involved. And so it's interesting to me at that level that suddenly censorship is an antitrust problem, that we can see it violate the antitrust laws. And it's going to be very interesting to see how that plays out in court.
At that abstracted level of, one group of companies colluding against an entirely separate industry, is there any analogy for that kind of case? I can't think of another example off the top of my head of something that's quite like that, previous antitrust cases that have been litigated. Yeah,
there's some case law around it. There's a case a little ways back that had to do with wheat, actually. It dealt with macaroni. So there were all these companies, that made macaroni, and
Your Honor, the macaroni case.
So there are these companies that make macaroni, and you need wheat to make macaroni.
Yeah.
And there's semolina wheat and there's durum wheat.
Yeah.
Durum wheat is generally considered higher quality, but it's more expensive. And you had a situation where all these competing macaroni manufacturers agreed to only use semolina, and so not use the expensive one, and that was held to violate the antitrust laws, right? So
why were they doing that if it was
to save
cheaper?
money? They're doing it because it's cheaper. So ordinarily, the way competition works, it's not just price; it's quality too, right? And so
they said we'll all use semolina so that the consumers don't get a taste for durum because that'll lead to an escalatory.
It's more that one individual company might be saying, okay, I want to use the cheaper wheat because that's going to lower my costs. But if I use the cheaper wheat, somebody else might use the better one. And then they'll be able to advertise and say, well, our product is higher quality than theirs. But if we all agree to use the cheaper wheat, then none of us have to worry about anyone making that argument they have higher quality. We'll all have the same quality and we won't compete on quality.
Yeah. Right. And so in this case, the analogy would be that a group advertiser boycotts, look, if one advertiser steps out of the advertising scene, they'll get less benefits in terms of customer acquisition. But if they're all doing it together, they can force the behavior they want.
I'll let you complete the analogy. I won't apply it to our facts, but
fair enough.
Let those with ears hear.
What did the House Judiciary report say in terms of what did they find on the details of all of this?
Yeah, I encourage folks to go read it. It was pretty exciting reading. Well, for antitrust nerds, I guess. Yeah. But essentially, what they found is that you had all of these companies getting together and not just agreeing on standards for a whole industry, but they all wanted to get together and agree on standards that were going to help advertisers in a certain way. And the conclusion of the report was pretty unequivocal. They said, this conduct clearly seems to be a violation of the antitrust laws.
Mm-hmm. Interesting. Talk me through just the kind of landscape of antitrust enforcement against big tech in general right now. It feels like, what's the meme? It's nothing happens, gang. It doesn't feel like we've gotten to the point yet where there has been the sort of final decisions made on anything relevant that has changed the consumer experience in America. Is that moment coming? Is it going to ever feel like that?
We're at the phase now. We went through a period of simmering concerns, and people were starting to realize, hey, this isn't great. Things aren't working out so well. That escalated fairly quickly. Lots of concerns were voiced. Investigations were opened. We're now at an exciting part where lawsuits have been filed against, I think, every big tech company has an antitrust lawsuit against it. Some of them have multiple. Those are being litigated. US v. Google is the first big decision. It's an encouraging sign. But there's more to be done. There's a suit against Google over ad tech. There's a suit against Apple. There's the Facebook, Instagram, WhatsApp acquisition suit. There's a suit against Amazon. So there's a lot to play out still. But now we're starting to see the results, right? So we've got one in the win column, some others that still have to happen. There's other investigations that are open that are still pending, right? So we could see additional lawsuits filed. So everything is starting to mature in that process, and it's hurry up and wait, right? We have to kind of see how they continue to play out, and hopefully we've got one verdict. We don't know what the remedy is going to be. So it's a bit early to say what the outcome is going to be for consumers, or how soon consumers are going to benefit from this sort of flurry of antitrust enforcement. But it's an exciting time.
Yeah. We have an election coming up, I hear. Knowing full well at this point that, who the tickets are seems to be a question of influx all the time. How would you handicap and how is the antitrust community, to the extent that such a thing exists, thinking about how the winds might change on antitrust enforcement and the broader regulatory landscape if it's, DJT versus the K-Hive in the White House here in 3 or 4 months?
Yeah, I think I have not been asked any other question more than that over the last month or so. And I have to apologize for the typical totally unsatisfactory lawyer answer of it depends.
Yeah.
The bottom line is personnel is policy.
Yeah.
I think neither campaign appears eager to run on antitrust as a big part of the platform. That's probably a product of how politicized antitrust has become in the last several years. It's potentially a product of tension between donors and the base, who I think have very different interests when it comes to antitrust policy. But I think we're just not going to know. We're not going to know until somebody wins the election and then names their appointees to run the FTC and the antitrust division.
Yeah. What's the range of things that really matter when it comes to the overall antitrust policy of the federal government? Like, what are those handful of positions that people should keep an eye out on?
Yeah, the two biggest ones are the Assistant Attorney General in charge of the Antitrust Division and the Chairman of the Federal Trade Commission. Those are the two heads that run antitrust enforcement. Obviously, the people beneath them matter, as well as the other minority commissioners at FTC. Yeah, I was telling someone recently, there's in the past, you're a presidential nominee, you get elected, you start figuring out who you want to fill out your cabinet, who you want to run your administration. When you get to the antitrust division, it wasn't a super complicated process. You want to find somebody who is an experienced, competent, well-respected antitrust lawyer and who's on the team, right? Like they're a Democrat or they're a Republican. They're sort of a known quantity. They're going to be a good team player. But as far as substantive antitrust positions, there wasn't that much consideration given to it. There was a consensus, right? The antitrust bar all pretty much agreed for a long time about how the antitrust law should be interpreted and applied. So you weren't looking to say, like, are they a neo-Brandeisian or are they a libertarian or are they whatever, it was just who's a good lawyer and who's in my party. We don't live in that world anymore. And so, when I say personnel is policy, I really mean it. This isn't something where they can hand this off to a junior staffer in the White House to go pick out someone to run the antitrust division. When they name nominees to run the Federal Trade Commission and run the antitrust division, whether they want to or not, either administration will be taking a policy position on what the antitrust laws mean and how they plan to enforce them. I don't think there's any way around it. Even if they tried to pick somebody who they thought was just neutral, that's going to be making a statement in and of itself. It's going to be taking a side in this debate. We don't have a consensus anymore. All of this is in flux. There are very different views within the antitrust community, within the antitrust bar, over how the antitrust law should be interpreted and applied. And so, when the next nominees are chosen, they're going to be taking a side in that debate one way or the other.
Can you walk us through just a little bit of what the specific authorities between the FTC and the antitrust division at DOJ are? Just because I think, that set is said frequently, but I think understanding the division of labor
we
is
have a
helpful.
very unique setup here where we have two agencies sharing enforcement of the antitrust laws. It's kind of funny because for years, our agencies have sent representatives overseas to help other countries set up their antitrust enforcement regimes. And they go over and they're like, yeah, don't do it the way we do it, just to be clear. No one, it's an open joke in the antitrust bar that no one would choose to set things up the way we have it now if we were starting from scratch, but it is what it is. We have the antitrust division within the Department of Justice, and we have the Federal Trade Commission. Federal Trade Commission handles antitrust enforcement as well as consumer protection. Antitrust division just does antitrust. The antitrust division enforces the Sherman Act, the Clayton Act. The Federal Trade Commission enforces the Clayton Act and the Federal Trade Commission Act. This is where it gets weird. So Section 5 of the FTC Act prevents unfair methods of competition. The way that's been interpreted is that anything that violates the Sherman Act violates Section 5. Anything that would violate the Sherman Act is an unfair method of competition. It's understood that Section 5 is broader than the Sherman Act, but we don't really know how. FTC hasn't brought a lot of cases where they say, we're not claiming this violates the Sherman Act, but it definitely violates Section 5. It's called a standalone Section 5 case. They don't do that often. Has
Lena Khan done more?
She issued a policy statement that, tried to flesh out a vision for what that means. It doesn't provide a lot of clarity. So we still don't know, I think, until we have a case that's actually brought and they say, here's a set of facts and we believe it violates Section 5 in this way. So when all of that means that substantively FTC is looking at their cases the same way that DOJ is 99% of the time. They're looking at, does this conduct violate Section 1 or Section 2 of the Sherman Act? And then when they plead it, they technically plead it as this violates Section 5. But they plead it as this violates Section 5 because it violates Section 1 or Section 2. So they have overlapping enforcement. Big difference is that only DOJ does criminal antitrust. So like hardcore price fixing cartels, that's all done at DOJ. And then one of the greatest ironies in all of this is that the two agencies engage in market allocation. So each of them has certain industries that they focus on. That like if you're doing oil and gas, it's going to end up at FTC. If you're an airline, it's going to be at DOJ. If you're anything in healthcare except health insurance, you're going to be at FTC. But health insurance will be at DOJ. It's a very strange thing. And then others they fight over. So
there's monopoly power. In antitrust enforcement.
We have an antitrust enforcement duopoly. They engage in market allocation. With no sense of irony. And then the rest of it they fight over.
Where did that industry carve up? This is a kind of an emergent phenomenon over time.
Yeah, some of it, it's kind of developed over time, different areas of expertise. There's this whole arcane system that no one outside of the antitrust world knows about or would necessarily care about, where the agencies fight over investigations. So that's called a clearance process. So before either agency can open an investigation, they have to get clearance from the other agency to do it. And so in the industries where they have clear division, like we always do this, you always do that, it's like, yeah, sure, go for it. When it comes to things like big tech, where they've both been involved, they will fight hand, tooth, and nail over that. In Republican and Democratic administrations, they put on a nice, happy face about being best buddies in public. And behind closed doors, they're at each other's throats arguing over who gets to do what case. Mm-hmm. In some cases, delaying investigations by months as they try to sort out. And they do all these weird things of, okay, you can have this case this time, but you can't cite it as a precedent for the next time this industry comes up to say that you have more experience than we do.
Who's the final adjudicator?
There is none.
So they just have to agree.
They just have to agree. One time, they are both on Independence Avenue. There's all that stands between DOJ and FTC is the National Archives. One time, the head of the Antitrust Division and the chair of the FTC walked to in the middle of the street in front of the National Archives and flipped a coin. That's how they decided it. That's the world we live in. Welcome to America.
Crazy. Wow.
Yeah.
So harmony between those two agencies on policy is pretty important.
It is. Yeah. It's very important to have harmonious policy. Under the Trump administration, we had a situation where DOJ was going into court as an amicus on the side of the defendant in an FTC suit. Right. So the two agencies were actually arguing against each other in federal court.
Wow.
So it doesn't always work out well.
Yeah, that's super interesting. Mark, how can people keep up with everything that you're doing?
Our law firm's website is KressinMeador.com. I occasionally post some tweets I probably shouldn't.
Yeah.
But
Twitter's good.
but that's where they can find our website.
Yeah. If you would like to bring antitrust suits,
right,
go to Kressin Meador.
If you have an antitrust complaint, I'm your man. For sure.
Yeah. Help Mark make up for years of working on the Hill.
Please help feed my children. There's a lot of them.
Yeah.
They keep asking for food.
How many are you up to? 6?
6. Yeah.
6. Yeah. Awesome. Love to hear it. Mark, thank you for coming on the show.
Thanks for having me.
Hopefully you guys enjoyed that. We certainly enjoyed taping it. As always, be sure to go to AmericanMoment.org. There you can find the backlog of this show and everything else we have cooking. We're having a lot of fun here at American Moment these days, so definitely come visit us and talk to us if you have any questions about how to best get involved here in a pretty interesting season in American politics. Be sure to rate and review this podcast 5 stars only. Become a member on YouTube, either a truther or a statesman, and be sure to join us next week for yet another fantastic episode. Thank you guys, as always, for listening. We'll see you soon. Moment of Truth is an American Moment podcast taped at the Conservative Partnership Campus Studios and is produced by Jake Mercier, Jared Cummings, Tiffany Kutris, and Matthew Pearson. Our intro song is A Minor Struggle by Ryan Serenich, and our website is AmericanMoment.org.